Okay, perfect. Shall I start with my presentation?
Yes.
Okay, perfect. So, hi everyone. The impact of Gen AI on the duty of confidentiality within legal practice. Why should we talk about this? Why does this matter? My thesis is that Gen AI will impact confidential client data in novel ways. So now is the time for lawyers and other professionals start a discussion about how the duty of confidentiality will be fulfilled in the future. So I hope this can be a starter for wider discussion. But first, a short introduction of myself. Hi, I'm Victor. I hold a German law degree and a British Master of Science in Legal Technology. Until recently, I've worked as a venture manager for Unternehmertum, Europe's biggest startup incubator, where I was part of the team that was fine-tuning a legal AI model. Now I'm focusing on beginning an PhD project on the regulation and governance of AI. So my presentation will be structured in three parts with an emphasis on the third part. First, I want to establish what the duty of confidentiality is and how it evolves in the context of the legal profession. For that, I look at three distinct sources that have shaped it: the legal ethics source, the regulatory source, and most importantly, the common law source. Then in my second part, I will use two recent studies to briefly introduce the critical use case of Gen AI in legal practice, current and proposed use cases. And because this is a Gen AI conference, I will not abstractly explain the technology behind Gen AI, but rather reference it when it's relevant in the later parts of the presentation. And then in the third and final part, I will draw on the foundation of the first two parts and highlight what I think are the most consequential impacts of Gen AI on the duty of confidentiality within legal practice. So let us begin with the first part. What does the duty of confidentiality entail? Broadly speaking, it puts the solicitor under a general duty to keep secrecy in all the affairs of the client and to ensure that all they supervise adhere to the same responsibility. But what that means in practice is shaped by three complex authorities. As I've said, the legal ethics, regulation, and common law sources. Due to the scope of this talk, I want to focus on the source I find most consequential, the common law. But before that, I will briefly introduce the other two sources as they're deeply interconnected. I think really required to understand the concept of duty of confidentiality in its totality. So let us first look at the ethical source of the duty of confidentiality. The strict duty of confidentiality can at times be at odds with the moral standards of everyday life. So, for example, if someone witnesses another person commit a crime, even if it is his or her friend, this person might be under moral obligation to report the crime to the police. From lawyers, on the other hand, we expect absolute secrecy about the dealings of their clients due to their unique relationship. This tension is the subject of considerable debate in the field of legal ethics. To give you a brief introduction of this discussion, I will just highlight two essential justifications. Of course, there are way more. So for Andrew Boone and other legal ethicists, the duty of confidentiality is justified by the rule of law and administration of justice rationale, as well as the client autonomy rationale. For them, the task of lawyers is to ensure that all individuals can enjoy their rights and preserve the client's autonomy. To achieve this, he argues that lawyers must understand the client's best interest, including what they wish for themselves. This, they argue, can only be achieved when clients have complete confidence that what they tell their lawyers will remain secret. Then, after the ethical source, is also the regulatory source. The duty of confidentiality is subject to the SRA Code of Conduct for Individuals 2019, which regulates the conduct of solicitors in England and Wales. And there is the Article 6.3, who explicitly forbids the disclosure of confidential information for clients. And non-compliance can actually result in regulatory actions like reprimanding solicitors or even revoking their licenses. But the thing is that this norm does not tell you what the definition of disclosure in this context means. So at the end of the day, the interpretation really depends heavily on the applicable case law. This is why I think that the case law at the end is the most important part of the source of the duty of confidentiality, but intertwined with the ethical and regulatory sources as well. So then let us come to the common law source, where I will just briefly introduce a few case law examples I think are most consequential for the theory and the duty of confidentiality with legal practice. So one of the first mentions of the duty of confidentiality actually dates back to Law Commissioner Whitelock in the 17th century, who actually considered advocates as a kind of confessors to whom the client should be free to lay down all the true facts of the case without interference. From there on, the duty evolved to what we now see as the modern duty of confidentiality in the case of Rockerson versus Monday, Ellison Clark in 1912. They are a firm of two solicitors who were in the habit of doing business separately and without knowledge about the client's affairs. And there was a claimant to bring forward an action for wrongful dismissal of a country, consulted one of these partners. Subsequently, this plaintiff changed the solicitor, and after a writ has been issued, the matter was referred to arbitration. The other partner, who knew nothing of the colleague's past involvement, agreed to act for the company defendant in arbitration. To stop this, then the plaintiff sought an injunction. After the injunction was granted in first instance, the Court of Appeal reversed this decision. And there, Lord Justice Buckley held that the court may grant an injunction to prevent a solicitor from directly using knowledge acquired as a solicitor of the old client to assist the new client. But, and that's important, that there is no general rule, so every case depends on its own facts. Because here, the partner in question had no direct knowledge of the firm's former client, no probability of mischief or prejudice could be found by the court. And it was also held that a complete prohibition could have caused great difficulties in a small town where the choice of solicitors is, of course, limited. The case and these principles that were established in the Rockerson case were workable rules for the professional environment of the time, when the legal profession was dominated still by sole practitioners and small law firms of less than 50 lawyers. But after the Second World War, the economy shifted away from these small family-owned businesses to large and professionally managed and externally owned companies. The law firms themselves evolved with them to cater to these new needs of these bigger and more professional companies, and also grew substantially in the process. In order to retain the ability to act against former clients, the new organizational structure of these law firms had to be addressed. This is highlighted by the landmark case of Balkia versus KPMG in the year 1999. KPMG, as you probably know, a firm of consultants, had acted as auditors for the Brunei Investment Agency, BIA, since its creation in 1983. Prince Jeffrey Balkia, who had been the chairman of the BIA until he was removed from the office in 1998 as a result of a dispute with his brother, the Sultan of Brunei. While still in office in 1996, Balkia engaged KPMG's London office to conduct an investigation related to litigations it personally involved in. It was called Project Lucy. As part of this work, KPMG's forensic accounting team gained substantial amounts of confidential information regarding Balkia's personal finances. So then, in June 1998, BIA commissioned KPMG's London office with an investigation into the withdrawal of assets from BIA that was suggested at the time to have been utilized by Balkia for his own benefits. This time, a project called Gemma. Well, KPMG realized that this might have been against Balkia's interest. They still accepted the assignment without seeking consent from shares. So they agreed to also work on the second project, Project Gemma. To prevent the flow of confidential information regarding Balkia's financial affairs they had gained in the first project, Project Lucy, KPMG's London office erected a so-called information barrier, formerly known sometimes as a Chinese wall, to separate the teams of Project Gemma and Project Lucy as much as possible. Different partners and personnel were assigned to both projects. Additionally, Project Lucy was isolated in a designated area with the instruction to keep all documents regarding Balkia from leaving it. Against this, Balkia sought an injunction restraining KPMG from continuing Project Gemma, which was then granted by the House of Lords in September 1999. Lord Justice Millett held that while there is no rule of law that information barriers are generally insufficient to eliminate the risk, the court must be satisfied on the basis of clear and convincing evidence that all reasonable measures have been taken to ensure that no disclosure will occur. In considering the facts of the case, he said that KPMG had established the information barrier ad hoc and only within a single department. Additionally, both projects had rotating memberships with individuals joining or returning from other projects. He held that the information barrier erected by KPMG was therefore insufficient to mitigate the risk that confidential information inadvertently come to notice to those working on Project Gemma. Although KPMG was ultimately restricted from acting for BIA, information barriers themselves soon became the tool of choice for law firms and other professionals, like for example banks, to adhere to the duty of confidentiality. So, how such information barriers are currently handled is highlighted in detail in a very recent case, the Bank of London Group Limited versus Simmons LLP case from the year 2022. In March 2022, the claimant, the startup bank BLG Limited, engaged Simmons & Simmons to advise them with respect to regulatory matters. At the time, the law firm inadvertently failed to notice that it had as a client another bank, BLME PLC, that might have adverse interest of the claimant. In August 2022, the trademark department of Simmons & Simmons wrote a letter of claim on BLME's behalf, threatening passing off proceedings against BLG on account of the similarity of names. In those proceedings, Simmons & Simmons argued that they had erected a sufficient information barrier between the two departments and that therefore there was no disclosure of confidential information. In relation to the timing and nature of the erected information barrier, Simmons & Simmons gave detailed evidence that when the partner of the regulatory department became aware of the passing off claim matter of the trademark department in August 2022, he immediately requested that the defendant's IT department lock down the electronic workspace containing the claimant's file, with the consequence that from the following morning, only he was able to access it. The general counsel of Simmons & Simmons indicated in a statement that the defendant's IT department had thereafter erected an information barrier that limited the access to the electronic files to those who were identified on the request form. Considering those facts, Stuart Isaacs concluded that an effective information barrier was established as soon as practicable, and therefore there was no real risk of disclosure of the information in question. The application of injunction was subsequently dismissed. When we consider all these highlighted facts, I think that the main takeaway here is that the duty of confidentiality, as well as the means to fulfill it, for example, information barriers, had always had to evolve in the context of the changing technological and social economic circumstances. So now, I hope we have an understanding of duty of confidentiality by all these three sources that play interconnectedly to give us the modern duty of confidentiality, so the legal source, the ethics source, as well as the common law source. So now let us look in the second part on how GenAI is currently tested and used within legal practice. So for that, I used two recent studies from 2023, which I think give us a clear indication in this regard. One is the International Legal Generative AI report from LexisNexis. The other ChatGPT and Generative AI in Legal, Corporate, and Tax Market report from the Thomson Reuters Institute, both from 2023. You see a small excerpt from both studies here on the right side. When we compare the results of both surveys, I think three groups of current or proposed use cases can be deducted. First, legal research, then knowledge management, and third, document drafting and review. Legal research in its current form has its beginning in the move of the legal profession away from libraries towards online databases like 50 years ago. First, the exact citation had to be entered into these systems to retrieve a specific case or statute. Then subsequently, the system moved on to keyword-based searches. While those systems already resulted in increased efficiency, the system often still retrieved hundreds of answers, were prone to errors, for example, missing cases that use the word automobile instead of car. Machine learning and GenAI impact this tyranny of the keyword, like the economists call it, into fundamental ways. Where conventional systems do not connect individual search queries, GenAI systems get more accurate the more context you give them about the queries. Secondly, machine learning, and GenAI in particular, enables searching for concepts that cannot be expressed with a few keywords or are prone to misunderstanding if interpreted without context. An example would be that a Dutch sandwich is being a particular text strategy, of course, and not in this case, the food. Lawyers are primarily knowledge workers. Therefore, most of the law firms' value and even their distinguishing features are stored in their knowledge management system. By integrating all those assets into a single LLM, large language model, the lawyer can search the whole knowledge base of the firm by inputting open-ended search queries in natural language. For example, what do we know about the certification process of wind turbines, without the need of complicated interfaces of older structures. Because the system works with context and concepts, as discussed above, users don't have to know what kind of content they are looking for before prompting the system, thus lowering the threshold to access of relevant knowledge. Now that the foundation regarding duty of confidentiality and the use cases of Gen AI with legal practice is laid, I want to come to the heart of this presentation. How the duty of confidentiality is going to be impacted by the use of Gen AI within legal practice. First, let us talk about the advertent or inadvertent disclosure of confidential information. New information technologies have constantly changed the legal profession and thereby always presented new challenges to the duty of confidentiality, as we have seen with the highlighted case law before. Some authors, like Weisberg or Hudek, argue that AI is just another computer program, so we should treat it identically to, let's say, email, Word, or maybe Excel. And indeed, if unencrypted email communication became the norm of legal work in the mid-1990s, soon the fear emerged in the legal profession that its use might be inadequate to protect confidential client information due to its risk of being intercepted or otherwise extracted online by malicious actors like hackers. The same was subsequently said of cloud computing since its widespread adoption in the 2010s. The main argument brought forth in both of these cases were that, first, while further documents can be stolen, of course, access to them was generally limited to a few individuals, while information that is hosted online can theoretically be targeted by a global and incalculable number of malicious actors. Second, that the data passes through one or more servers owned and controlled by third parties, who might access its content or fail to protect it against outside threats. And lastly, that solicitors lack the technical experience to officially foresee or prevent those information risks. If a Gen AI model is accessed via the cloud, especially from a third party, as it is most common right now and probably will be in the future, then it suffers, of course, from the same risk of being breached as email communication or cloud communication more generally. But I argue that while we can learn a lot from the advent of email communication and the cloud, the special nature of large language models that are powering Gen AI will result in consequences that conventional programs do in fact not share. The potential of email and cloud for breaching confidentiality comes mostly from third-party actors, like hackers or careless cloud providers who externally access the system in unintended ways. In contrast to that, I think that Gen AI with its unique training process, as well as its ability to generate content, might advertently or inadvertently disclose confidential information within a law firm without any third-party actors involved. Instead, for example, suppose a solicitor uses a Gen AI tool for legal domain-specific tasks, like we have discussed before, legal research or maybe document drafting. In that case, the system might create an output that includes confidential information of a former, current, or prospective client. This can happen either inadvertently, if the lawyer in question doesn't seek the confidential information, but gets presented with it anyway, or advertently, if the solicitor has prompted the system intentionally in the way that extracts as much of the source data as possible. As the generative models create the text token by token, the output will most likely be not an exact copy of the confidential information, but it still might carry the gist with accuracy. If, for example, the system is prompted with the name of a certain client, this name will be embedded with the tokens that appear alongside the name in the training data. Much in the same way, as the system might, for example, output the correct birth date of a celebrity, because this information often appears alongside each other in the training data. It then might accurately output trade secrets, for example, of the client, because these informations, like, for example, trade secrets, might just be embedded close to the token, for example, of the name of the client. So there's always a risk that this confidential information will be outputted with the name or some other information that might be close in the embedding vector that was created for these GenAI models by training it with the data of the client. But as with every other tool, I think there are ways of preventing this from happening. Leakage through the trainings data, for example, could be prevented by omitting potentially confidential information, or pseudonymizing it beforehand. Leakage through the users could be prevented by instructing them not to use potentially confidential information data in prompts. Then there's another possibility of using department-specific LLMs with limited access. But of course, none of these solutions come without drawbacks and trade-offs. Pseudonymizing or omitting client data might be, for example, limit the use of knowledge management systems. Legal research tool, on the other hand, might be less impacted by it. So while establishing department-specific access-limited LLMs might also solve a lot of the problems regarding confidential data, it might at the same time increase costs and decrease efficiency relative to one large model covering the whole law firm. So I think at the end of the day, I believe that every law firm will have to make a case-by-case assessment in this regard. So let's come to another really important part of this new influence of GenAI on the duty of confidentiality. It's highlighted with the discussed case law, information barrier, although often scrutinized by the courts, like in the case of Bolkia versus KPMG. It still can be an effective tool to prevent the breach of confidential information within law firms if it is erected timely and on an organization level, like in the Simmons case. I want to argue that GenAI tools like law firm-wide knowledge and management tools or document drafting tools would challenge this relatively stable status quo. While conventional data storage can be locked down and subsequently protected with different firewalls and access rights, this would currently not be possible within a single LLM, as the training data is not literally stored in the neural network, but rather in representations thereof in the form of the billions of tuned weights and biases that can, at least as is right now, not be separated from the model. While it is beyond the scope of this talk, it should be also noted that this will also create heavenly problems for the right to be forgotten under the GDPR. So, of course, there are implications beyond the duty of confidentiality, but due to the scope of the talk, I will just give that note here and then be that lest it be. What I think is in practice, this might mean that the model size and thus cost effectiveness and scalability must be balanced with the ability to remain able to erect effective information barriers if necessary. At the same time, GenAI might also benefit information barriers and keep them relevant in a time of big data. The effectiveness of information barriers depend on the ability of the law firm to locate every document and personnel that might hold confidential data. Due to the sheer amount of data that are now created in law firms daily, I think this task is increasingly impossible to do manually. Additionally, with the ability of transformer-based models, large language models, to quote-unquote understand concepts and context, they will catch relevant communication that other programs might not. For example, if the client's name in question is not explicitly told but implied in email communication, the AI system will still flag it. Additionally, those systems will produce a coherent and summarized answer in human readable text so that it can be directly processed further by relevant departments. Another advantage might be that the black box nature of LLMs that are often, of course, harmful because they can lead to hallucinations and other issues we can't really track down because we don't really understand what happens inside the neural network. Here, it could even be an advantage because the output will not be traceably connected to the country information. So using it inside of the law firm will be easier than in the case of directly connecting the confidential information to the information barrier that is needed to be erected. Let's come to a third part I deem really consequential with the impact of generative AI. In the previous discussed case of Bolkia versus KPMG, it was also established that for there to be a breach of confidentiality, relevant client information must have been disclosed. It was held that relevant confidential information is limited to information given in confidence and related to a specific retainer. Therefore, information gained accidentally, for example, via general correspondence or behavior in litigation, would not count towards it would therefore be not protected. That seems sensible today, but I want to argue that due to the ability of generative AI to extract patterns of meaning out of the text and to mimic it, this status quo must be reconsidered in the future. Suit law firms could collect all information of a former client that is currently below the threshold of individual confidential information, like gender consents or behavior litigation, and use this to conduct a sentiments analysis or to train an AI model to mimic the style of the client. In this way, the law firm might be able to gain valuable insights that would otherwise not get. Such a tool could be, for example, used to simulate or predict the behavior of the client in negotiations or to prepare cross-examinations. Suppose this type of analysis becomes the norm in the future. In that case, clients might react by purposely drafting their communication in a way that gives the AI models as few opportunities as possible to deduct patterns from it, or even actively trying to manipulate the outputs of shots AI models might create. Much in the same way as websites are now structured with search engine algorithms in mind. I think that this could harm the proper administration of justice that is at the core of the duty of confidentiality, as it would, to a certain degree, obscure the interests and motives of clients. Courts could handle this by lowering the threshold of what is considered relevant data, but of course that would entail the risk of severely obstructing the work of law firms. So this is why I would like to propose amending the Code of Conduct for law firms and other actors in the legal sector, instead of a clause that would bar them from using AI tools like big data analytics, more generally to analyze and mimic the behavior and sentiment of former current clients. This way, the autonomy of clients could be protected, which constitutes an important justification of the duty of confidentiality. So the finding of my work, of course, can only be an introduction into a wider interdisciplinary discussion involving computer science, legal and ethical experts. One of the reasons I think that conferences like the Gen Icon is so important, because we're all these different actors together. And at the end of the day, such tools like Gen AI are just a tool, like email have been, like cloud computing have been. I think it's in the hands of legal profession to actually shape it. So thank you for your attention. If there's any questions left, please contact me by email or LinkedIn. The slides will be shared if you're interested, and I hope you enjoy the rest of the conference, and goodbye.